All right, well, welcome to our webinar today. My name is Justin Terch. I'm going to turn on my video. You may want to utilize it or not. That's entirely up to you. We are here today to talk about COVID-19 and the effect on employers up in northeastern Minnesota, northwestern Wisconsin. There's well over 100 people registered, and there's already over 100 people already watching this today. We're going to try to be as efficient as we can with our time and go over a lot of material. So if we aren't able to answer your question, though, at the very end, there is our contact information, and we'll be happy to get back to anybody with their answers to their individual questions if we haven't been able to answer them throughout the webinar. I'm excited today to be partnering with a colleague of mine, Craig Chilcote. But before I turn it over to him to introduce himself, I'll tell you a little bit about our practice. For those of you who don't know me, my name is Justin Terch, and I own a firm called Terch and Associates. And we have 5 consultants in Minnesota. 2 full-time up here, 2 part-time up here, and 1 person down in the Twin Cities. And we really work with all kinds of employers, from small agencies with 5 or 10 employees all the way up to corporations with 1,000. Because of the kind of work we do, we have been dealing with a lot of questions about COVID, a lot of questions about the federal legislation with regard to paid sick leave. And so we really thought this was a great opportunity to partner with our friend over at Kuiti Asuma. The good news is that we're actually co-located in one place, both firms, and we have really been working together, helping our clients answer questions they have and just make sure that they have all the information they need. We're right downtown Duluth, and like I said, at the end, our email and phone number will be available to you. And I'll give Craig a chance to tell you a little bit about himself and Kuiti Asuma.
Hello, everyone. Thanks. I appreciate everyone coming today. I see 107 participants at this point, and we're excited to do this presentation. Later in the presentation, when I take over, we'll switch up the video here. But you know, for right now, we've had some real unprecedented legislation over the last couple weeks, and in fact, it is literally changing on a daily basis. And so we've been getting a lot of questions from our clients regarding everything from the new tax credits to SBA loans to, you know, when do I file my tax return? So we're going to cover a lot of those topics today. And just as a warning, some of these things continue to change. We're still clarifying how we're going to implement some of these new credits. And so sometimes the answer is, I don't know, and we are researching it and getting additional information. So feel free to use the Q&A to give your questions. Anything we can't answer today, I'll be happy to follow up with you via email. And just to back up a little bit, Craig Chilcote here. I'm the managing partner at Kuiti. We are a firm based in Duluth. We do individual taxes, corporate taxes, a lot of tax planning and consulting, payroll and bookkeeping. Our focus really is business owners from 500,000 to 5 million a year in revenues, but we do a lot of 1040s. We work with a lot of retirees and professionals as well. And so we've been working a lot doing research to give our clients some of the best advice as these credits are getting implemented and as these new loans are available. So I'm looking forward to going through my section here and giving everyone an update of what we know so far. And I'm going to turn it back over to Justin to go through his section, and then I'll pick up after. Thanks.
Great. All right. Well, we're going to cover a lot of stuff today. I just wanted to give a brief overview. We're going to talk in some depth about the paid leave legislation at the federal level. There's been 2 cornerstone pieces of legislation that have been enacted by Congress in the last few weeks: the Families First Coronavirus Response Act, and then the CARES Act. So we're going to go into some detail about how they impact you and your employees. And then we're going to end up with Craig talking about some detailed information about how to handle the financial implications of what's going on and opportunities for some relief. We're also going to touch on things like unemployment insurance. We did have some people submit questions beforehand when they registered, so we're going to try to answer those. We're going to talk about the Duluth Earned Sick and Safe Time issue as it relates to COVID-19. I know that not all of our participants are in Duluth, and that's just fine. It's only going to be a slide or two. So the vast majority of the information we're going to be talking about is really applicable to all employers, except for the Duluth ESST issue. And our unemployment questions are going to be primarily using Minnesota information, just because most of the registrations were from Minnesota. If you are in Wisconsin and you have questions about unemployment, just let us know. Send me an email and I promise we'll get you the best information we can. So the first thing we're going to go over is provide some general overview of the paid leave legislation. As most of you know, it's been an active few weeks in Congress, and they have really, in many ways, drastically changed the face of the employer-employee relationship, at least as it relates to time off and pay. So the first piece of legislation we saw was the Families First Coronavirus Prevention Response Act, and that was enacted last week. And it's effective today, actually, and it expires at the end of December. So it expires on New Year's Eve at the end of the day. And so it's important to realize that even if your employees end up coming back to work, if there is a qualifying need, this is still an issue that you'll have to provide through December 31st for most employers. It's really one of the first pieces of federal legislation that created the right to paid sick leave for employees. And it amended the FMLA statute, the FEMLA statute, to add a new qualifying reason, which is the loss of childcare. And it lowered the eligibility criteria. As most of you know, FMLA usually applies to 50 or more employees, and the employee has to work there for a year or more before they're eligible. And that kind of went out the window as it relates to this narrow reason of childcare loss. Of course, it's also required that you pay the employee for the time off, but the act did provide for tax credits that Craig will talk about that will help hopefully offset the cost of providing that benefit. Additionally, there is a new poster requirement. So if you're not aware of that, please let us know and we'll get you a copy of the poster. You are required to post it in your workplace, or alternatively, you're allowed to deliver it via mail or an electronic delivery like an email in lieu of posting it in your workplace. The next piece of legislation that was passed came last week. It's called the Coronavirus Aid, Relief, and Economic Security Act. It did many things people know, have read and seen in the news, a number of pieces of this legislation, including the check that people are going to be receiving for $1,200. But in addition to some of that stuff, it did modify the FMLA portion of the previous week's law, and we'll talk about that. And then it also expanded opportunities for unemployment insurance to make it a little easier for people, including self-employed people and independent contractors, to obtain benefits. Okay, so really that Families First Act has two big provisions that's going to relate to us today. The first was emergency paid sick leave, which we're going to talk about now. And the second one is that paid FMLA leave. And so they are different. And I think as I was reading the statute and answering questions of our clients, it seemed easier if we looked at them as two separate pieces of legislation and we interpreted them each on their own merits. And so that's kind of how I'm going to be walking through this summary with you today. So the emergency paid sick leave applies to all employers that have fewer than 500 employees. So whether you have 1 employee or 499 employees, the requirements are the same essentially. It also applies to all government employers regardless of number. So if somebody has 501 employees and they're a government agency, like a school district or a county, they are going to be covered as well. A covered employee is any employee. And this is going to be different than the emergency paid FMLA leave. For the emergency paid sick leave, it doesn't matter who the employee is. It doesn't matter how long they've worked for you. It doesn't matter how much, whether they're full-time or part-time, whether they're in a union or not, or whether they're an executive or entry level. It applies to all of your employees. In order to access emergency paid sick leave, the employee has to meet one of these 6 criteria. The person has to be quarantined by a government order, like a county or a city, or even a state order. They can be, another qualifying criteria is being advised to quarantine by a medical provider. One person asked us in anticipation of the webinar what a medical provider is, and we're going to talk about that as well. But a note or any type of communication or documentation from a doctor or other medical professional that says, you should quarantine at home, that's going to be enough to trigger this. Number 3 is if you're experiencing symptoms and you're waiting to get your test results. Obviously, we've been reading lots about tests and test availability lately. Caring for somebody who has been quarantined or advised to quarantine is also a triggering event. Caring for a child because their school or daycare closed as a result of COVID-19. And then, of course, number 6, which is as vague as you can get, which is other substantially similar conditions as determined by the Secretary of Labor. And Secretary Scalia has not, I'm sorry, that's the DHHS. The DHHS Secretary has not listed what those are yet. The amount of leave is 80 hours, and part-time employees get 2 weeks. And the next slide, we're going to talk about how we calculate that. But essentially, if you have an employee who meets one of those 6 criteria we just reviewed, they get up to 80 hours of paid sick leave. For our part-time employees, the statute tells us how to reach the number. It says that we should take the average hours scheduled over the preceding 6 months, including time that the person was not at work as a result of leave. So that might mean a part-timer's counting their sick time or their vacation time that they weren't at work, or even if they were eligible for parental leave or FMLA leave, you would count that as well. And if there isn't 6 months of employment history, if the part-time employee has been hired within the last 6 months, the amount of leave needs to be based on what the employee's reasonable expectation of scheduled hours were at the time they were hired. So for many of you, that means looking at your employment offer letter or your job advertisement and trying to understand if it's not really clear, trying to get some clarity on what the reasonable expectation was. And I would encourage employers to err on the side of caution and avoid cutting corners when you're doing this calculation. So here's an example. On average, over the past 6 months, John's worked 762 hours. We take that 762 and we divide it by 26 weeks, which is of course 6 months, and it gives us 29.3 average hours per week. So John should get 58.6 hours of emergency paid sick leave if he experiences one of those 6 criteria. Now, how much do we pay them is the next question. If the person meets one of the first 3 criteria listed, they were quarantined, they were advised to quarantine, or they have symptoms and they're waiting for a diagnosis, then the employer is obligated to pay the employee for that employee's hours their full regular rate of pay. And the limit on it is $511 a day, or a total of $5,110. So if the person's daily salary or pay exceeds $511, you only have to pay them the $511. So again, everybody gets the 2 weeks. The question is how much money they get for those that missed time. If they're in the first 3 categories, they've been quarantined, advised to quarantine, or they have symptoms and they're waiting diagnosis, they get their full regular rate of pay with a limit of $511 per day. Now, if they meet one of the other three, the second set of three, they're taking care of somebody who's quarantined, and it doesn't matter who, doesn't have to be their child or their spouse. They're caring for their minor child because their school or daycare is closed, or they meet that really vague sixth condition where the DHHS secretary lists a similar condition. Then you need to pay them only 2/3 of their normal rate of pay. And the limit is dropped down to $200 per day or $2,000 in the aggregate. So again, if they're meeting the second set of three, so in other words, they're not necessarily quarantined, they're not necessarily experiencing symptoms, but they're caring for somebody who is, or they're taking care of their child because the child can't go to school or daycare, or some other similar condition, it's 2/3 of their normal rate of pay with a limit of $200 per day. There are some other provisions. The first is that employers cannot make employees use regular time off, even if it's paid, in lieu of taking the paid sick leave. Okay, so you can't, if you had an employee, we had an employer who, when this first happened here in Duluth, they went to all their employees, it was a nonprofit, and they said, we're gonna allot 2 weeks of paid sick time just for COVID. They called it COVID time. And many of those employees took that time and used it. And about a week after it was all used up, this law took effect today. The employer is obligated to start over and give them another 80, provided they meet that requirement. So just realize that if you gave them time before, it doesn't count towards this time. And you can't make them use their usual PTO in substitute for this. So if they have, let's say your employee has 2 weeks of unused PTO in their bank right now, and they have one of these 6 reasons, you have to give them this 80 before you can make them touch the rest of their time, okay? You can't make them use your time before they go into this 80 hours. And that is sometimes confusing to people. So if you have questions about that, let us know. We already talked about prior leave, even if it's for COVID-19 reasons. If it occurred prior to April 1st, it doesn't count. You have to start over. There's no retroactive coverage. You can't require your employees to find coverage for their shift. I don't know a lot of folks that still have this problem, but sometimes in the in more entry-level jobs, maybe it's in the food service, sometimes even in healthcare, there's kind of a requirement that people find coverage for their shift. That's not allowed in the use of the emergency paid sick leave. So it's the employer's responsibility to deal with that problem, not the employees. All right, so now we're going to move to emergency family medical leave. So keep in mind, in emergency paid leave, that's 80 hours. It's either paid at 100% of their rate of pay or at 2/3 of their rate of pay, depending on their reason. But emergency family medical leave is a little bit different. And in this case, the covered employer is again an employer who employs less than 500 employees. So it's very similar to the emergency paid sick leave. Additional to that is any other employer who's covered by the usual FMLA statute is also covered by this new statute. And that, again, usually we're talking about public employers, especially small ones. A covered employee is different though. In order to take advantage of emergency FMLA, the employee has to have been employed for at least 30 days. There is a caveat that the CARES Act included that we'll talk about in a minute. But in order to be a covered employee, you need 30 days of employment, calendar days, not working days. And then the employee, of course, must have a qualifying need related to a public health emergency. And it's very clearly defined here. We'll talk about that. But first, when we talk about covered employees, one of the things that the CARES Act realized was that some employers had laid people off or shut down operations in March. And this law is effective today and goes to the end of the year. So they had a concern about an employee who was laid off because of coronavirus, and maybe in May or June, they get rehired or called back. And they wanted to make sure that those employees were also eligible for relief under the law. So last week, this was included in the statute. So if you laid somebody off after March 1st and you rehire them or bring them back, provided that before you laid them off, they had 30 days of employment, they're going to be eligible for FMLA leave as well. So just be aware of that, that laying somebody off or even ending the employment, if it occurred after March 1st, it doesn't really change things if you bring them back. So what is a qualifying need? So a qualifying need under this part of the law is defined as an employee who is unable to work due to a need for leave to care for a son or daughter under 18 years of age if the school or place of care has been closed. So it's kind of a broad statute. It says, basically, if you have a child under 18 and they need care, they get the time off. I do think there's a difference between having a child under 18 be at home and having a child under 18 who needs care. And the statute uses the word to care for. And so, while there is certainly room theoretically for an employee to kind of be loose with the reasoning, I would encourage employers to just inquire for some employees who maybe have an older child if they need to actually provide care for that child or not. We did have one employer who was concerned that they had some employees who were coming in and asking about leave for their 15 and 16-year-old child who was otherwise quite healthy and capable of self-care. So you're going to have to use your discretion as an employer, but I read the language as you are in front of you as leave to care for the son or daughter under 18. There's some additional definitions. So schools only include elementary and secondary schools. It doesn't include colleges or universities. And you wouldn't think that's an issue, but sometimes we have 17-year-olds who have already graduated and are enrolled in a college or a university. And child care provider does not necessarily mean grandma or another family member. The statute says that it's a provider who receives compensation for providing child care services on a regular basis. So this is daycares, daycare centers, schools, things like that. It can also include a family member if they're the usual and customary person that cares for the child, but it doesn't include a one-off babysitter or something like that. So the employee gets up to 12 weeks of leave if they have a qualifying reason. So again, they've worked there for 30 or more days and they need to care for their child. That's the only reason that they can access the full 12 weeks of leave, is if they need to care for their child. The first 2 weeks under the FMLA portion of the law says that it's unpaid. And that created some real confusion when this first came out, because it seemed like the first 2 weeks were just unpaid, and they are under the provision of the family medical leave, but they're not under the sick leave. So in reality, those first 2 weeks of that 12 is covered by the emergency paid sick leave that we were already talking about. So how much do you pay the employee? Well, you have to pay the employee 2/3 of their regular rate of pay, just like under the emergency sick leave. And for part-time employees, you're going to use the same calculation. It's verbatim wording in each part of the statute. They carbon copied it. And then the limit here is $200 per day and $10,000 in the aggregate. Now, some employers may be exempt. The Secretary of Labor, Secretary Scalia, is supposed to be publishing procedures allowing employers with less than 50 employees who claim that following this law will be a unnecessary detrimental burden to their business, some way of applying for that exemption. Those regulations haven't been published, and Secretary Scalia has, under the law, until April 17th to publish them. And so I would anticipate there being some form of exemption option there. I'm not sure how big of a door that will be, but we'll have to wait and find out. So here are some common questions about emergency paid leave that we've taken in the last few days. So the first question is, what if the employee was already laid off on April 1st? If the employee was already laid off on April 1st and you haven't brought them back, then they're not eligible for these paid leave laws. If you call the employees back to work and then they have a qualifying situation, like they have symptoms or they've been quarantined or they need to care for their child, that's different. But if your employees as of today are on leave, or are on layoff, and they remain on layoff, they don't receive benefits under these laws. And that's directly from the guidance of the Department of Labor. The next question is, what if I lay off an employee after April 1st and they're receiving this leave when they're laid off? So for employees who are out on emergency leave and the employer ceases operations during that time, provided they cease all operations, then the employee stops receiving paid leave because they'd be eligible for unemployment. The employer is still obligated to provide the compensation, though, through the date that the employer shuts down all operations. So keep that in mind. The next question is, do you have to continue health benefits? You do. You have to provide health insurance for the employee if they were on the plan prior to the date that the person experienced the qualifying event. So if you're paying health insurance yesterday and today they walk in and say, I need leave, you're paying health insurance this month as well. The employee has to continue to pay their portion, just like they do now, but you can't put them on COBRA or make them pay all of it or cut them off entirely. That's prohibited under the statute. Can my employee use my usual paid time off plan as a supplement? So this came in, a number of employers called and said, I have employees with huge amounts of paid sick leave banks. If I end up having to pay somebody 2/3 of their salary under this law, can they use their earned paid time off for the rest of it so that they can get a full paycheck? And the answer from the Department of Labor is yes, they can. As long as the agreement is in writing and it's agreed to by both the employee and the employer, it's acceptable. So I would encourage you, before you institute this, to make sure that you get an email exchange between you and your employee or some other written documentation that just is evidence that the two of you understand what it means. And then you can certainly continue to issue them full paychecks that balanced third out of their bank and the first 2/3 under the statute. Keep in mind, for Minnesota employers, this new wage theft law has some documentation requirements that you might want to consider when you are making those types of agreements. The next question, who is a healthcare provider for paid leave purposes? So this question comes in two forms. The first has been, who can write documentation when my employee comes in and says, I can't work? Who can sign that documentation? And then the other one is, there is a provision under the sick leave and FMLA emergency statutes that says employers can exclude employees who are healthcare providers or emergency responders. So in other words, the fire department doesn't have to give time off to their firemen and EMTs under this law because they're emergency responders. The emergency responder definition is pretty broad. That would obviously include your firefighters, your EMTs, your police officers, any type of law enforcement or field emergency worker would qualify under emergency responder. Healthcare providers, however, is quite narrow, and that's mainly because the FMLA law already has a definition for healthcare provider, and neither the CARES Act or the Families First Act modified it. And so healthcare provider includes these: doctor of medicine or osteopathy, podiatrists, dentists, clinical psychologists, optometrists, and chiropractors, nurse practitioners, nurse midwives, clinical social workers, and physician assistants. This one always gets everybody: the Christian Science practitioners listed with the First Church of Christ scientist in Boston, Massachusetts. I have no idea why the law exempt that particular profession, but it has always been classified as a healthcare provider authorized under the FMLA law. And then it includes, hidden deep in the FMLA statute, is anyone who the employer accepts medical certs from for benefits claims purposes. Usually it's just the doctor, but if you do accept it from anybody else, I would guess the one that comes to mind is if you allowed a birthing doula, for instance, to sign something, then theoretically you would have to for other things. So we had a question about group home employees and whether they could be excluded from this law as a healthcare provider. According to the regulation, no, they cannot be, because they don't meet the definition of a healthcare provider. So it has to be one of these professions. If they are in one of these professions, you certainly have to accept signed releases from them for your employees. And you may also exclude them from taking advantage of the leave themselves. If they're not on this list, you may not. Okay, unemployment insurance. We've had a lot of questions about this as well. So there's been changes here in Minnesota. As some of you may know, Minnesota had a number of executive orders. Some of the provisions include that benefits payments won't be charged back to employer accounts. And this is helpful to know that if your employees go on unemployment insurance in Minnesota at this time, your benefit account will not be charged for that. And that I'm sure we'll pay for it in some other way, but it won't be through unemployment insurance tax. It eliminates the waiting week. Sometimes people don't realize that when you apply for unemployment, the first week that you're unemployed, you don't get paid for. It's called the waiting week. And Minnesota proactively said that they were going to waive the waiting week requirement. That is true now also in Wisconsin, by the way, if you're a Wisconsin employer. And then additionally, they waived the 5-week benefit holdback for business owners. So some business owners choose to pay unemployment insurance on themselves and their own wages. And historically, there's been a 5-week exclusionary period for those people when they experience loss of employment. And this executive order from Governor Walz waived that 5-week period of time. So in theory, if you're a business owner who does pay unemployment insurance on your own wages, you should be eligible just like any other employee immediately. Now, we also added some qualifying reasons. Typically you only got unemployment if you had a loss of position or a reduction in hours through no fault of your own, or at least through things that were not misconduct. But now the law's been amended to broaden that. So it can include a temporary or permanent layoff or hours reduction due to COVID. You can collect it when you're sick or when you've been ordered to avoid contact with others due to COVID by a public health authority or a healthcare professional. If an employer tells an employee not to come into work because of an outbreak of COVID-19, that's also a qualifying reason. And then, of course, you'll see a common thread here. If your children need to have care because of their school or daycare being closed, you're also eligible to receive unemployment insurance. So you'll see there's like layers of pay for that issue, whether it's paid sick leave, emergency paid family leave, or unemployment insurance. There's multiple avenues for employees to get wage reimbursements in the case that they can't go to work because their child or children are home. In both the Families First and CARES Act that President Trump signed, it included that requires notify employees about unemployment when they're laid off. So that's just as simple as when you write your employee a letter saying that you're doing a layoff, telling them that they may be eligible for unemployment. and to contact the Minnesota Unemployment Office. It doesn't have to be anything fancy, it can just be in a letter. The federal law also allotted an additional $600 per week to eligible participants. Typically in Minnesota, the most, regardless of how much money you make, the most you can collect is $640 a week. So this almost doubles that amount of money that a person could recover for higher wage earners. Further, it extended benefits for an additional 13 weeks through the end of, I believe the end of July. And that's probably for people who are on unemployment already, but who are about to lose their benefits. It gave them some additional time. And of course, it expanded eligibility under federal law for COVID reasons, as well as providing benefits to self-employed workers. Some states hadn't already taken advantage of their executive orders like Minnesota had, and so the federal law kind of pushed that along. So another question we had in the registration section was, how are benefits calculated? So Minnesota takes something called a base period of wages that they look at for each employee. And it is the first 4 quarters of the most recently completed 5 quarters. And typically it's about 50% is what you get, up to a cap of $640. So if you were to apply for unemployment today, the wages that they would look at would be the calendar year of 2019, since as of today, we're now in Q2. So I know it's kind of complicated, but if you have other questions about that, let me know. But they would basically look at your earnings in 2019, and they would calculate about 50% is what your benefit would be, up to $640. Now keep in mind, there's an additional $600 in the federal package as well. So it would be more than that if the calculation came up that high. Another question we had is, what if my employee just doesn't want to come to work, regardless of whether it's a safe place to work or it's, there's no quarantine, or they are considered essential, all these questions. Well, the Minnesota DEED, the Department of Employment and Economic Development that administers unemployment, has come out publicly on their website. They've stated that employees who refuse to work are encouraged to apply for benefits. Doesn't say that they'll give them, but they're encouraging people to apply. And we don't know at this point how the adjudicators in St. Paul will decide what is a reasonable work refusal and what isn't. The good news, again, though, is it won't count against your unemployment tax account. Of course, it might create some workflow problems and work stoppage issues. So we don't have much to talk about with ADA, equal employment opportunity, and some other considerations, but there's 1 or 2 things I wanted to touch on. The first is that if you are hiring people and you have moved to a fully remote workplace, meaning all of your employees are working remotely, the Immigration and Customs Agency has said that they will not require you to physically inspect I-9 documents. You can basically have them email you a scan, and you can look at them on the scan or on the computer screen. Just write in the additional notes section COVID-19, and then when you resume operations, re-inspect those documents and note the date in the additional information section on page 2. If any of your operations are not remote, this doesn't apply to you. So they were pretty clear, this only applies to organizations that are completely remote. An interesting trend we saw last month was companies taking employees' temperatures. It's usually a no-no to do that. That's not usually allowed. It's considered a physical examination under the Americans with Disabilities Act, and the EEOC has been pretty sensitive about that in the past. But they did issue guidance that said during this limited amount of time and circumstance with COVID, they will not charge any employer with taking reasonable steps like taking employee temperatures in order to stop the spread of the disease. It is important, though, that if you're going to take temperatures or do anything like that, well, first I encourage you to talk to somebody either in our office or with your employment counsel's office, just to make sure that you're doing it right. But it's really important that you don't pick and choose who you take the temperature of. You don't want to target particular groups because you can open yourselves up to other claims. So if you're going to be taking temperatures, it should be everybody or nobody. It shouldn't be particular groups of people or individuals. All right, for our Duluth employers, there's not too much to say about this. Ian hasn't said anything from the city clerk's office, but essentially at this point, ESST remains in effect. You have to continue to comply with the ESST requirements, and remember that if somebody has a need that qualifies, they get their federal time off before they get their Duluth sick and safe time off. So you got to give them that that first 2 weeks covered under the federal statute before you can have the employee tap into the ESST. So just make sure that with all these different laws flying around the room, that you're really taking a look each at the individual basis and looking at the rules and being careful about how you apply them. And at this point, it's time for my friend here, Craig Chilcote, to take over. And I'm going to go ahead and mute myself, and we'll be off and running, hearing about hopefully something a little bit more exciting than earned sick and safe time and all the things that go along with it. So with that, I'll turn it over to Craig.
Hello, I'm just going to get my presentation going here. All right. Sounds good. Well, let's go back here. All right. So thanks for joining today. See, we're still holding at 1:14. So Justin, thanks for the great job there. Although ending with taxes is always kind of a tough run, but let's take a look at some of the things that have occurred so far. And, you know, when this coronavirus started, the federal government has really done three things to kind of kickstart the economy and work on some of these challenges. So the first thing is they extended the tax deadline. So that was the first thing, and we'll talk about that on the next slide. The second thing is they started implementing some tax credits. So this was through the Families First Coronavirus Response Act. And this is the one that gave some employer tax credits for payroll. And then the third tool that they're using is this Coronavirus Aid, Relief, and Economic Security Act. And so really they're kind of taking a three-piece approach. And let's kind of go through these pieces. What we're going to do is I'll kind of go through the slides and the highlights. I did see a couple questions that I'll answer. And then anything that we don't get to at the end, what I'll do is I'll make sure to circle back with you and give you an opportunity to get some of your questions answered. So, you know, the first thing, let's talk about the tax deadlines. So the 2019 income tax filing and payment deadlines has been extended to July 15th of 2020. Now this relief is going to apply to individuals, trusts, corporations. It's automatic. You don't have to do anything. We have some people who already extended. We don't have to do anything different. The one thing to keep in mind though, right now, as of today, as of an email that I got today, Minnesota is in compliance with the federal for the extension for the individual returns along with individual and corporate returns. But the estimated tax payments are still due on April 15th. And so that was one of the things that came out, and what we're looking at is seeing if they're going to make some changes. Haven't heard anything yet, but as of right now, your Minnesota individual tax return and Minnesota corporate return are due the same day on July 15th as on the federal return. So we're in compliance there, but there are a couple other pieces that we're waiting to hear from Minnesota on. Estimated tax payments are due. Your first estimated tax payment, which would have been due on April 15th, is due on July 15th. And your second estimated tax payment is still due on June 15th. So you're going to pay your second first. And then anything after July 15th is when your penalties and interest are going to start. So right now, your tax return doesn't have to be filed until July 15th. And also you don't have to make your tax payment until July 15th. All right, let's go to the next slide here. Okay, we're going 2 slides. All right, so the next thing is tax credits. And so we have really 3 kind of main ones right now. We have the 100% reimbursement of paid leave, which this was part of the Families First Coronavirus Response Act. And this is from what Justin spoke about on the required leave for people affected by coronavirus or their family members affected by coronavirus. So this 100% reimbursement paid leave is a way that employers can get repaid by the government for paying for this leave. The second one is employee retention credit and the payroll tax delay. Those were both part of the Coronavirus Aid, Relief, and Economic Security Act that came out last Friday. So let's talk about the 100% reimbursement paid leave first. So under the guidance that is still to be released, so we know pretty much how it's going to work, but as far as the actual mechanics of it when filing the returns, right now it looks like we're going to still do it under the 941s, which will follow that, but still waiting for the final guidance on that. So eligible employers who pay qualifying sick or childcare leave will be able to retain an amount of the payroll tax equal to the amount of qualifying sick or childcare leave they paid. So when you are an employer and you run payroll, depending on your size of business, within 2 business days, 3 business days, you have to pay your payroll taxes. Well, what this credit does for you is it allows you to not pay those taxes and retain them. And basically it's an advance of your credit that you would get. So this is how you can keep cash flow going. You're paying out your sick pay. And what you can do is not pay in your full payroll taxes. And so one of the questions we get is, what if my payroll is more than the taxes? Well, and then you'd file the payroll, you would not pay the taxes, and then you'd have a credit to carry forward. Now, according to this guideline, it says the reimbursements will be relatively quick, immediate dollar for dollar offset, and where a refund is owed, the IRS will send the refund as quickly as possible. So these are the 2 kind of unknowns. So we know if you're going to go to pay the taxes and you don't pay the taxes because you're applying for this, you're basically getting a credit. We know that you're going to retain dollars in your business, but if you do pay more than the taxes you owed with the payroll, how fast will you get the refund and how will you get it? We just don't know that yet. So it's out there, it's going to be available, but the mechanics of it, how soon you're going to get it, how soon you'll get it refunded to you, we're still working through. All right, so that's the first credit. Now we have the employee retention credit. So with the Coronavirus Aid, Relief, and Economic Security Act, there are a couple credits that came out for employers. And the first act's credits were related to paying employees and how to get credit for payment of the sick pay. These next two credits were more for the business. How can you keep your business going? How can you keep cash flow going? And so with this, we'll take a look at either if your business was affected by COVID, either fully or partially shut down, or if you had a 50% drop in revenues compared to the same period of last year. That's really the two determining factors. The maximum refundable credit is 50% up to $10,000 of eligible wages per employee. So basically each employee that you have, you can get a maximum refundable credit of basically $5,000. If the business employs less than 100 employees, the above limitations do not apply. So if your business is just struggling and you're under 100 employees, this is an option for you. You don't have to be directly affected by COVID, and your sales don't have to be down by 50%. The one thing to keep in mind with this employee retention credit is we're going to talk a little bit more in the future slides here, but if you end up taking this SBA Paycheck Payment Protection Loan, which we're going to talk about, that means you cannot take this credit. So the thing to keep in mind is if you're going to apply for some of these loans, which we'll discuss, I would say you're going to want to hold off on any of these payroll credits first. See how the loan application goes or the approval process goes, and then go and potentially take these credits if you didn't qualify for the loans for some reason. So the other credit was this payroll tax delay. And really what that one is employers and self-employed individuals, you can defer a payment of your employer share of FICA taxes. This is not all of your taxes. This is just the portion of taxes that the employer pays. And so basically what you do is the portion of employer taxes you would not pay in 2020. You would get a credit. You're getting a loan from the government, and they're saying you can hold off on this payment and you can pay half of it back to us on 12/31 of 2021. Hold on, this slide keeps going here. I guess these slides are starting to go ahead on me. Hold on, a little technical difficulty here. All right, we're getting close. Okay, we have the employee redemption, we got the payroll tax delay. So half, this PowerPoint presentation is starting to take a life of its own. So half of those taxes would be due on 12/31 of 21, and half of them would be due on 12/31 of 22. So again, you're not getting a credit. All you're doing is putting off paying those taxes over the next 2 years, half in 2021 and half in 2022. And again, the same thing with this one. If you take the SBA Paycheck Payment Protection Loan, you can't utilize this program either. So with this particular one, I think that the one concern that I would have is just the record keeping on this, just to make sure you have good records in place. Now, it should be flowing through on your quarterly payroll tax report, but for the most part, you're going to have to track the taxes that were unpaid and make sure you get them paid in by the appropriate dates. So this one is going to have a little extra paperwork. You're not necessarily getting out of anything. You're just kind of borrowing, you're borrowing some time for cash flow. All right, so those are kind of the three big credits there. Now let's talk about the recovery rebates, which have been hitting the news. So these recovery rebates are for individuals that each taxpayer could get up to $1,200. Joint filers could get up to $2,400. Each taxpayer could get $500 per qualifying child, which would be under the age of 17, with no limit on the number of children. Income phase outs, 75,000 single, 150,000 for joint returns, 112.5 for head of household. And as your income gets above those phase outs, you start reducing those credits. You must have a valid Social Security number, and you have to file a federal tax return for the year 2019 or 2018 if you haven't filed 2019 yet. Now, there's been lots of questions with this. Supposedly something that I read today said they want to start sending out checks within 3 weeks. Okay, so they're going to follow the last return that they have on hand for you. So if there's direct deposit in there, if there's direct deposit information in there, they're going to direct deposit your check. If there isn't, they're going to send you a check. Now, you have people who haven't filed yet, so they think, well, maybe if my income is down this year, in 2018, I wouldn't qualify. In 2019, I might qualify. So should I file? And the answer is, well, yes. But we don't know when the cutoff is going to be. They say they're going to start cutting checks in 3 weeks. So I don't know at what point when you file the 2019 return it counts, if they're going to start sending out checks right away. And so that's kind of one of the unknowns. The other thing I've been reading about is that the individuals who haven't filed in the past because they haven't had to, well, in the act itself, in the rules, in the Coronavirus Aid and Relief Act, they said that if they don't have prior returns on file, they'll take a look at your Social Security statement. So this would cover retirees who are getting Social Security. Then the IRS recently put out guidance that said you're going to have to file some sort of a simple return to let them know. But we don't have any information on that, what that simple return is. They've been getting a lot of pushback from individuals who are not able to leave the house right now, who can't get a hold of anyone to help them file this return. And so we're kind of waiting for guidance on this one. What is this simple return? Because as of this morning, when I checked the IRS website, it didn't have any additional guidance. An article came out this morning about it. I haven't seen anything yet. So maybe, hopefully we will get some guidance. I think another question I've received is, well, I don't have direct deposit on file because I've owed the last couple of years. Is there a way that I can get them my direct deposit information? Well, according to an article I read earlier this week, there's going to be a way to do that. There's going to be a form to fill out. I have not seen that form, and I have not seen any information on it as of yet. So I'm not sure what that form is going to look like. Again, we're just kind of waiting for guidance on that for these particular checks. So those are kind of some of the areas that we're really looking at, is to say, okay, how are we going to implement some of these? And what are the forms that will need to be filled out if you haven't filed before? We're kind of waiting for guidance on that. All right, we covered recovery. Let's talk about some other tax updates. There's kind of a whole host of them within this last law that was passed last Friday. I picked a couple that I think would be more applicable. But one of them is charitable contributions, $300 above the line on the tax return for 2020. Well, due to tax laws in 2018, a lot less people have been itemizing deductions because the standard deduction got so high. It got to $12,000 for an individual and $24,000 for a married couple. So a lot of people weren't using charitable deductions to itemize because they were taking the standard. Well, this new law says you can take $300 as a deduction above the line, which means on the front page of your tax return, you can reduce your gross income by $300. So I think what this is an incentive for people to give to charity, people who weren't really getting any benefit off a charitable deduction. This gives you a little bit of a benefit. You know, another thing to look at is you can take $100,000 from a qualified retirement plan through the end of 2020 without paying the 10% penalty. You know, if you're under 59 and a half, you have not been able to access funds out of your retirement plan without a 10% penalty. So they're waiving the penalty. There's quite a bit to this actually section, but you know, the things to remember are you have to be affected by COVID, and you can take the money out without a 10% penalty. You do have some repayment options. You have to, if you pay it back within a period of time, you don't have to pick it up as income. So not only can you take it out, but you can actually pay it back. There's a whole bunch of rules with that. If you have specific questions about that, we can kind of chat offline about it. And then RMD rules waived for retirement plans in 2020. So any individual who's older than 70 and a half who's been required, now those rules have changed recently too, but just say for argument's sake, anyone over 70 and a half that has started to have to take required minimum distributions out of their retirement plans, that is waived for 2020. So anyone that is taking that out and picking it up as income because they've been forced to, they don't have to do it for 2020. And final, there's several more, but I think this was the other one that changes is to the net operating loss rules. So those rules have changed. In 2018, they limited how you could handle net operating losses. Going forward here with this new tax law, losses incurred in 2018, 19, and 20 can now be carried back 5 years. And the income can be fully offset. Before, you could only offset about 80% of your income. So for those business owners out there, if you had losses in 2018, 2019, you had some limitations on carrying those losses back. Those limitations are gone. So there's some opportunities to go amend some prior year returns and hopefully get some tax money back. All right, so those are some of the kind of broad tax updates. Let's talk about loans. So this is really where I've been getting probably the most phone calls, is these loans that the SBA has put out there. As of Friday, they let us know what they were. Looks like last night, some of the applications actually came out and were available. I think the banks are getting guidance this week on how to implement these, because many of these are SBA loans through your lender. And they should be opening up for taking applications by the 3rd. So anyway, this has been a big area of discussion. So really kind of some of the key SBA loan programs out there that we have right now are the Paycheck Protection Program loan, which is probably the most common one I've been getting questions about. You have these economic injury disaster loans and emergency economic injury grants. So you have some loans and grants. These are for disaster areas. Minnesota has been declared one as of about 2 weeks ago. So there are loans available. There's a $10,000 grant, which is a relatively quick turnaround time. And then there's some economic injury loans for business for help you with cash flow. And then part of this through Minnesota, the state of Minnesota has some loan programs too. The small business emergency loan up to about a $35,000 loan, partially forgivable, but those are some also local loans. So let's go into a little bit of detail about these. So the Paycheck Protection Loan. So $350 billion was authorized in order to guarantee these 7A loans. So the SBA has had these 7A loans already available. What they did is this loan actually is created running on this framework of the existing 7A loan. And basically it's a loan you can get to cover payroll costs, interest on mortgage payments, rents, and utilities, kind of the core basic functioning of your business. It applies to businesses with fewer than 500 employees, or those that meet the SBA's current size standards for 7A loans. Applies to self-employed or individual contractors, and applies to certain nonprofits. So there's a pretty broad path of businesses and nonprofits that are available, that can have this loan available to them. So this is the one as of last night. I just saw the application come out. It's about a 4-page, pretty basic application. You're gonna apply them, supply them with payroll information, and you're gonna apply through your bank that is basically an SBA lender. So the maximum loan size for borrowers is capped at the lesser of 250% of the average monthly eligible payroll costs. Basically, you take the average payroll costs that you have, and you multiply it by 2.5, up to 10 million. Interest rate is going to be capped at 4%. Now, the beauty of this loan is that it is partially forgivable. So when you apply for the loan, you're going to apply through an approved lender. You're going to, when you receive the loan, you have some record keeping to do on what you spent the proceeds on. And when as long as you're spending the proceeds, you have an 8-week period for when you spend money on payroll, your rent, some of your core expenses, basically payroll, rent, interest on mortgage debt, utilities. When I say payroll, that does include health insurance as well. For that 8-week period, the money that you spend, as long as you can verify that that's what you spent the money on with the loan proceeds, you can apply with your lender to get that amount of money basically forgiven. So that chunk of that loan can get forgiven with this additional record keeping through your vendor or through your bank. And, so this to me is the most powerful loan that they have available right now for business owners. A lot of people are going to qualify for it. Now, there are rules on how to do it. If your employee count goes down during this period of time, basically it's from March 1st through June 30th. If your employee count goes down, your forgiveness can go down as well. If you cut your employees' pay in this period of time, your forgiveness can go down. But one question that comes up pretty regularly is, what if I've already laid people off? Well, as we've done some more research and looked through this, even if you've already laid people off, if you're using these proceeds to hire people back, you qualify. So even if you have people laid off, they went on unemployment, if you can hire them back and you're going to use these proceeds to pay payroll to keep people working, that is what's going to be forgivable. So, some people say, am I too late? I laid people off already. I'm going to say, no, you just keep going. You apply for the loan, because there's a big question on process. We have a lot of people that are going to be applying for this loan. So my big question is how fast? The banks are just kind of getting ramped up for this loan program. So we don't know from the time you apply to the time you receive proceeds, what is that length of time? Okay, so that really is probably the one I hear the most about. The second most common one you're hearing about is the economic injury, disaster loans, and emergency economic injury grants. So these are low interest loans offered by the SBA for people who have suffered economic injury. The loans can be up to $2 million. They're repaid over 30 years at 3.75% fixed rate. And the payments are deferred for the first 12 months. Must be a small business per SBA size standards. Unlike the prior loan, this one, loans over $25,000 require collateral. You need to do some sort of a collateral with these loans. The Paycheck Protection Loan does not have any collateral requirements. And so and it does have the forgiveness feature, which this one doesn't. So I think that's going to be the more common loan right now. But this one is certainly available. I've had several people apply for it. At this point, I haven't had anyone get through the process yet, but I've had people apply. So there are some other grants out there too. And these are loans that you can apply directly through the SBA for. So there's the web link. And it's the SBA.gov. So you would log in, there's some forms that you fill out, and you would apply online. I know that the website was slow last week. I don't know what it's like. I haven't checked it in the last day or two, but I know that it was slow, and sometimes people were having to log in early in the morning or later in the evening to really get on and get their application through. And now in Minnesota, we have this small business emergency loan. Again, this is where you apply through an approved lender. Loans are from $2,500 to $35,000, interest-free, 60-month payback. You have a 6-month deferral, possible partial forgiveness, and only for Minnesota-based businesses. So this is on the deed website. for the state of Minnesota gives the details on this. But it is through your approved lender, so you would talk to your bank about this product as well.
All right.
All right.
So we do have some questions here that we'll do our best to answer. But if anybody, if we have a question that we're not 100% sure of, or that requires a little bit of research, or maybe it's really specific to your situation, we're going to reach out to you directly so that we get you the right information the first time. But there are some, I have some general questions here, and I'll go through mine. I don't know how many we have time for, but maybe just a few minutes.
Sure.
So one question we have is, Amy asks, the payment for the emergency paid sick leave is gross pay, and then and then it's taxed thereafter, correct? That is correct. So whatever if it's 2/3, that's the 2/3 is the gross amount, and then you'll apply your normal payroll tax withholdings to that. Or if it's the full amount, same thing, you'll apply your normal payroll tax withholdings from that. Can an employer demand employee use PTO prior to applying for unemployment during this time? That is an interesting question. The answer is that if your policy allows it, if the policy says that employees have to use PTO, then yes. Or if you just pay it out in a lump sum, then the employee has to report that to unemployment, and that will result in an equivalent number of weeks being excluded. And we have had that a few times, but the unemployment program, the unemployment insurance program's guidance on that just encourages employees to use their PTO first. I'm sure, of course, because it reduces the burden on them, but also because employees get more money per week from their PTO, assuming it's covering a full week, than they would from the reduced amount from unemployment. And then somebody asked here, Craig, I don't know if you could see the questions or not.
I can, yeah, I can see them. I was going to go through.
Yeah, go ahead and go through yours if you want. I'll answer one more, and then
Sure.
And then we'll let you take a couple here. A lot of lone ones. That's good. Let's see here. Can the employee earn PTO while they're on emergency paid sick leave? That is a complex question. So again, that goes back to how your written policy is. When Minnesota passed the Minnesota Wage Theft Act, they basically said whatever the arrangement is between you and your employee has to be documented, and you have to follow it, or there's civil and in some cases criminal penalties. So if your policy or past practice has been that employees who are on other types of paid leave, maybe they're on 2 weeks of vacation for a whole pay period, if you credit them with PTO during that time, you should treat this the same way. So be careful to make sure that you're not changing how you handle this now, because you should handle it how your policy is written and what your wage theft form is that you and your employees signed last year when that law was passed, making sure that you're acting consistent with that. Craig, do you want to grab a couple?
Yeah, I will. I think there was a question on partnership tax returns. Were they also extended? Those were kind of already, that deadline was kind of extended already. That deadline was kind of passed before a lot of these things happened. So I would say that deadline was still in place for the partnership returns on March 15th. Are they subject to late filing rules? To me, I think if you have any opportunity to argue things were going on, this would be it. So generally, if it's the first time that you've missed a deadline and you send them a letter explaining why, a lot of times they will give you a break for this particular time. So I think the best answer to that I have to that one is the deadline was still in place. If you missed it, I think I would try to write them a letter if they're going to give you a penalty to try to get out of the penalty. Let's see. 8 weeks starts when? This is a great question regarding the payment protection loan. From what I've read, the 8 weeks starts when you get the loan, basically. I've seen it where the 8 weeks starts when you apply, but that doesn't make as much sense to me. I think as soon as you get the loan, that's your 8 weeks. Now, here's the question. How fast are you going to get the loan? So those are the things that I don't really know. I know that there's an 8-week period, and I think some of those are that determining factor is going to come out. But if you get the loan towards the end of June 30th period, the 8 weeks wouldn't make much sense. They'd have to go back. So it could be back to the application time as well. I've read different things on that. I believe it's been resolved. I just haven't seen that resolution yet, but I can always circle back to give the answer on that.
So we have a question here of what if you're a nonprofit and you have more than 500 employees? So if you are a non-government nonprofit and you have more than 500 employees, you are not subject to the emergency paid sick leave or the emergency paid FMLA statute. Again, you have to be a private nonprofit with 500 or more employees to be exempt. Do you have any other questions you wanted to answer online, Craig?
Let's see. I think I did. Comment on provisions for small farmers that do not have material amount of wage expense and are self-employed. This really gets back to what you're going to report for either payroll or distributions. And so depending on what kind of an entity you are, you'd take a look at whatever you receive for pay, depending on what kind of entity you are. Since you're not doing official payroll, it could be related to distributions that you take out of the company. The other thing is it may be that it would be a small enough amount where the 2.5 times wouldn't really be worth it. So maybe you'd take a look at some of the other loans available. But that, that's a good question. But I think that if you don't have wages, there's, it's pretty clear on its compensation somehow. So depending on the type of entity, it's either going to be wages or distributions or guaranteed payments. If you don't have those, then doing the calculation may be tough. Let's see, Justin, this is, I guess, for us, several questions on the slides available. I don't see why we can't, I don't know, what do you think, emailing those out would be best, or what are your thoughts?
We'll make sure to email the slides out to all the attendees.
Yeah.
We will, just because we promised to be done in 1 hour and 15, I think at this point what we'll do is if we haven't answered your question live, we will be reaching out to you within the next 24 hours with an answer via email. Is that fair, Craig?
Yep, makes sense.
Side as well?
Yep.
And just remember that, if you need anything, we're staffing our office here. We are co-located. Craig has a team of about 15 real crackerjack CPAs and accountants on his staff. We have a team of HR consultants on ours, and we're really partnering to get you comprehensive answers to your problems. And we're happy to take phone calls and emails and try to help you get through this kind of difficult and confusing time.
Perfect. Thanks again. Thanks for joining, taking time out of your day, and we appreciate you attending.
Absolutely. Thank you, everybody. Have a great day.